So, everybody, this is David Melvin. He's actually my attorney in Nova Scotia, and phenomenal lawyer, but even more so a phenomenal person. He has done a lot of good things for my business partner and I when we've gone through our various purchases in Nova Scotia. And he's, especially in the early goings, he managed to correct several of our mistakes, because when you start off, everything, right? So he took care of a lot of things. Now, back then he was a solo practitioner. Now he's part of a law firm, and he's charging us market rate now. Damn it! I don't know if I like that.
Nice, but I gotta pay the bills, man.
Yeah, I know. He's not your typical maritimer either. As you can see, he's in the office on a Saturday morning. It's like you are the opposite of what I want.
Well, nobody told me 11 o'clock happens twice in a day on the weekend.
Oh yeah. Yeah, it's still early for us. So what we figured we would just, what is it you guys would like to know about the Maritimes? Just to, it's an open forum, pipe in, chime in. What is it you're looking for? What information do you need? And the floor is yours if you want to go in. Like, we're not going to give a big presentation. It's more about answering your questions and seeing what your needs are. Or we can just be quiet. So simple things, I'll chime in. I was just mentioning this before. I'm based out of Montreal. My business partner is based out of Ottawa, and we were buying property in the Maritimes, right? This was our first major purchase. We had been doing rent to own in Quebec and in Ontario, and we decided that we wanted to get into the multifamily game, and we decided on the Maritimes. We decided on Nova Scotia first, found our property, and got it under contract, got the deal done 3 days before closing. Still trying to set up accounts. We're on the phone with Nova Scotia Power or Nova Scotia Energy, trying to switch the electricity over to our account, and they wouldn't open an account for us. What's your registry number? What's that? I don't know what that is. I can give you my incorporation number. So, all right, ding 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 ding. David, what's a registry? So this is something that takes a little bit of time, but we managed to get it done, I think, in 2 days. And our tenants had electricity, because you can imagine what it would have been like having 27 tenants with their first day with new landlords having no electricity. It would have been fun. It would have been so much fun to deal with that. So these are just the little things you need representation in the province that you're dealing with, because your lawyer in Ontario, your lawyer in Quebec knows the law, from A to Z in the province they're dealing in, but they don't know all of the little intricacies of other provinces. And every province has its little nuances on how they deal with. And we thought, hey, David, can you help us out in New Brunswick? No, Robert. I cannot help you in New Brunswick, but I can refer you to someone.
I can find you someone in New Brunswick to help you, but
yes,
because lawyers were licensed per province, right? So there is mobility rights. Like a lawyer licensed in Nova Scotia can practice in another jurisdiction for a certain amount of time, but it's like anything. There's the rules. There's all the stuff you learn in law school, and then there's the practical reality and how things function on the ground in every jurisdiction. And I don't know how to do a closing in New Brunswick, buying a property in New Brunswick. Could I kind of fumble around and figure out the steps? Probably. But am I a registered user on the land registry there so that I can record the documents? No. Do I know what searches I need to conduct to make sure that, and where to conduct those searches to make sure that, we're getting clear title? No, don't. Could I learn it? Yeah. But that would, I have to charge somebody money to learn it. So I normally in those cases say, listen, let's find you somebody in the host jurisdiction you're in. Because also, someone local kind of knows what's going on. Like, you see a great deal on a property and say, oh, let's buy that one. That's been on the market for a long time. The price has dropped. It's multi-unit. This is great. And then when you send the address over, it's like you do know that's like in the worst neighborhood in the entire area. And there was a stabbing there last week. I mean, it's just because it and I mean, real estate agents, they're marketing the thing, so they're not going to highlight the problems. So it's, it comes down to like, you just got to ask somebody local that knows what's going on and can tell you, like, oh, or, even who the vendor is. I mean, there are lots of guys out there that have portfolios that are selling them and stuff like that. And you kind of know the good ones, and the ones that are like, this person you're dealing with is, not to pass judgment, but this person could be a lot more work for you than you were anticipating on your transaction, just because of who they are, how they operate their business. It's like, or sometimes even who their lawyer is. It's like, got to tell you guys, if they were using somebody else, this would be half the price, but they were using this lawyer, and well, this is how they operate, and this usually results in you paying more.
Yeah, one of the things I like about working with you, David, is when we introduce the buyer to you. Oh yeah, I know their lawyer. Yeah, this will be an easy transaction.
And that's usually what it's usually one or the other. It's either, oh great, someone on the other side. And this is the same with lawyers everywhere. Like they're just lawyers are like anybody else. There's really good, helpful ones. There's ones that are kind of just coasting along. You name it, there's a type of person that's a lawyer. And it's sometimes a bit of a roulette wheel in terms of who you get on the other side. But yeah, if they have good counsel and you have good counsel, things tend to work a lot more smoothly than kind of in some practitioners are more kind of an absentee lawyer, like they're there, but they're not really dealing with the file. Someone else is managing it. And, if something goes wrong, it's really hard. You try and get to the person, and then they've got to learn what the whole file's about because they aren't really.
Sorry, I don't know if you hear that.
Yeah, I think it's Rafi. There we go. So I guess one thing I probably should point out is I see lots of folks are from out of Nova Scotia. So I had to kind of, this came about in April of last year. So in the kind of so before April of last year, during the height of the pandemic, I won't lie to you, there were lots of folks just like you guys in Ontario who realized that, hey, the rental market is, getting a rental property up here is tough just because there's so many people scrambling over stuff. And everything seems great down the Maritimes. No COVID, everything's chill, and there's a high demand for housing. And so let's wander down and try and buy an investment property here. And that was going on a lot. Like it was surprisingly large numbers of folks from Ontario just coming down, buying, some of them just sight unseen. I'm just buying this house because I want to rent the property. So it's like, well, okay. And that worked well, and it worked so well, however, it resulted in, the government, of course, having a panic to say, well, people can't buy houses now because all these investors are showing up, bidding up prices, and things are getting out of hand, and so we got to deal with it. So in April of last year, the government rolled out effectively a foreign buyer tax in Nova Scotia, which is a deed transfer tax. So it says if you buy a property in Nova Scotia and 50% or more, or I should say 51% or more of the owners are non-residents, and non-resident is effectively defined as you need to live here and you need to have a provincial health card and you need to pay your taxes here. So if more than 50% of the owners don't live in Nova Scotia, you have to pay a 5% of your purchase price tax right off the top to buy the place. And that's on top of whatever local deed transfer tax is applicable. And generally speaking, the big cities, Halifax, Sydney, that's 1.5%. So if you're a non-resident buyer and you're buying a rental property, just a single or 2-unit building, for example, you could face up to a 6.5% tax on your purchase price just to start.
That's only for smaller buildings, though, right?
Oh, yeah, for smaller buildings, exactly. If you're buying like a 20-unit building, that's a different story altogether. But this is effectively designed to try and free up housing stock for locals to own and live in. But once you kind of move into the larger dwelling units, I think it's over 4 units, then we kind of move beyond this tax. So it's targeted in that area, just literally just to make sure people can get houses. Now, how effective is it? It did put kind of slam on the brakes on a bunch of folks from Ontario buying things with me at the time when it rolled out. So that kind of helped, that dried up a bit. But there are still investors here buying, and it's really just comes down to, like most things when you're investing, you got to do the math, right? You got to figure out, okay, is this going to work from a purchasing cost, carrying costs? Are we going to be able to make the return we're hoping to make on this thing? And of course, some people say, well, why don't I just incorporate? I'll set up a company in Nova Scotia, and that'll be fine. The company lives there, so that's good. Yeah, the lawyers in the Legislative Council office were very clever. Don't worry. The moment this came out, we were all like sitting in this office together, like looking through the rules, trying to find a way around it, because that's what lawyers do. One person writes the rules and the next group tries to figure out a way around it. But they literally passed in part of the regulations effectively define what a resident is for a company. And that includes everything from, there has to be the majority of directors living in Nova Scotia. So, but even if you hired a bunch of lawyers to be your directors, if the managing control is outside of Nova Scotia, it's a non-resident. Or if more than 51% of the shareholders are outside of Nova Scotia, it's a non-resident. So they pretty much cut off every angle we could think of to try and make a company a resident here. So while legally, in the sense of the Companies Act, it's a Nova Scotia resident, for the purposes of the tax, they've defined their way to avoid anyone claiming that it actually is a resident. So in other words, the government wins, really. That's the long and the short of it.
So everyone aside from someone moved here, Laura and myself, is from Ontario.
Oh, okay.
And I'm pretty certain every one of them have heard me say this. Everything bad going on in the Maritimes with regards to real estate, I blame on Ontario people. And now they're all suffering because of their ignorance in their own province.
It's like, if you all came in the kind of a staggered pattern, it would have been better. Like, you all came at once. And that was the problem.
That wasn't the problem. The problem was they were so accustomed to overpaying in their own market that they were willing to do it elsewhere because it was cheaper. And they all got bit in the behind, right? So I like picking on Ontario. The other thing, if you could touch on, a lot of the people in this room will be using private mortgages and investors, should they be using their lawyer in their home province, or should they be finding a lawyer in, let's say, well, since we're talking to you, Nova Scotia?
Well, there's that usually turns into kind of usually we wind up doing this collaboratively, because ideally there's the lender, the person loaning money. They would probably have their own counsel, one would assume, looking to develop their security, because they want to make sure they're going to get their money back. That person would usually be setting out kind of the terms of the loan. This is what we want to do. Securitizing it, or giving them security in the land, usually would result in someone like myself, as part of the transaction, arranging to either prepare security documents to tie in with the loan documents to say, all right, and I will secure that against the specific piece of land here in our registry. But generally speaking, I mean, ideally, where you're dealing with a private lender, they will usually have the okay. So generally, the private lenders, they'll have someone representing their interest to some extent. And then we would collaborate with them as effectively your lawyer for the purchase. The Code of Personal Conduct of Lawyers does allow us to act for the buyer and the lender to some extent, with everyone's consent. And so usually what we do is we coordinate with them in terms of, all right, what do you guys have in terms of security you want? I would then prepare the security documents kind of in Nova Scotia form, how we normally would do it here. And then I would send that up to the lawyer in host, whoever the lender's lawyer is, to review, have a discussion with them, make sure we're ticking off all the boxes they're looking for. And then as part of the transaction, we would then record it, and I would effectively give a legal opinion to the borrowers, to the lender and their lawyer's lawyer, say, I've recorded your security. Here's effectively my certificate as a lawyer here, certifying that, yes, I put you on title. Yes, your loan is in first place. Here's the registration particulars. So in the event anything did go wrong, that lender would then be able to reach out to counsel. Hopefully it never would come to this, but reach out to counsel here to start a foreclosure if they ever had to. They would have all the information in place. And if it's wrong, that is to say that if you agree to give the lender first place security on your home, and it turns out that the lender's security is in third place, they would then be suing me because I gave a legal opinion saying I put it on in first. So that's what's kind of the design for, is to get someone local who can then make sure that they can certify to whoever's lending the money that they're getting the security they want.
Laura, you had a question.
Yeah, David, hey.
Hi.
How are you?
Very good.
You're in Dartmouth, right?
Beautiful Dartmouth.
I'm from Halifax.
The Brooklyn of Halifax.
So yeah, I'm originally from Halifax, but I live in Montreal, and I'm looking at properties in Nova Scotia. And my sister's still there, and I was just wondering if you heard about this, and just confirm it maybe for everyone, that the government once again has overstepped and has said by September, I think, that all Airbnbs in HRM
right.
in Halifax are no longer allowed to run on their own. If it's in your own house, like half of your house, it's okay. But if it's a separate proproperty, it can't exist anymore. Is that it?
That is generally the rule. I understand, and I haven't read the regulations because they just came out last week. Actually, the city council looked at it. I believe if you're buying them outside of residential zones, so that's to say more in a commercial area, I think you are able to get away with it, i.e. not being your primary residence and running it as an Airbnb. But generally speaking, if you're buying a house in any kind of residential zone, unless it's your principal residence, you won't be able to run it as an Airbnb hotel effectively.
So you can only do the long-term rentals.
Exactly. Yeah, at least a month a rental, as opposed to day by day, a couple of days at a shop.
What's your thought on that?
Not a big fan of it for obvious reasons. It impacts the investor class, because there are a ton of Airbnbs, like surprisingly large numbers here in Nova Scotia. And I've got a couple clients who do the same thing. They bought in homes. There's a couple actually near my office. They're in a residential neighborhood, but they were purchased purely for the purpose of running them as an Airbnb. And I drive by them every day, look perfectly fine, don't notice anything wrong with them. They certainly, they fix the houses up very nicely, so it's not like it's detracting or diminishing the value of the community at all. But politics being politics, and as usual, a couple rotten apples spoil the barrel, and people don't manage their Airbnb well. They get a couple of yahoos in there that cause a bunch of problems. The police get called, and then all of a sudden now everyone's crapping on Airbnbs.
Hotels have a lot of money invested in these cities too.
Well,
I'm sure they play a part in it.
Oh, I mean, they're certainly not discouraging it, but at the same time, their target market's obviously a little different. But they know, competition is competition, and if they can squash out any competition, they're going to try to.
Do you think that law will last? Is it meant to be like from now on kind of thing, or for a year and see?
It's supposed to start in September, and I mean, at least for the current government anyway, the municipal government, we don't have municipal elections again for, I think, another 2 years or so, or something like that. So it's got to be at least around for that until, if there's the same government has announced an increase in property taxes of 6% in HRM. It just came out on like Thursday or Friday. That's their target property tax increase rate. So that's on top of course, everyone's appraised value is going up significantly over the past 2 years. So whether this government will be around in a couple of years. Yeah,
they haven't done a very good job of keeping their word. Like they had been elected. One of their promises was to get rid of the hold on rental increases, but then they still haven't removed it, and we're almost 2 years in now?
Yep. Nope. That's the provincial side. Yeah, they've doubled down effectively on that for now. So they did let go of they used the Emergencies Act provisions to avoid what's called renovictions. The idea that if you're renovating you can compel your current tenant to leave to make a substantial change to the building. So that was imposed under emergency legislation to stop it. But now that the emergency has been taken off, that's been removed. So doing mass renovations and allowing you to remove tenants is now available. But that, of course, you have to usually go to the Director of Residential Tenancies to make an application and prove that you actually are doing major renovations. And that's where, of course, the comedy ensues in terms of what is a major renovation. Is this just your attempt to kick somebody out to raise the rent? And you get dragged into all that, public policy debate, and it's a roulette wheel, really. I mean, if you're showing you're tearing the whole damn building down, or gutting it to its wall studs, yeah, you probably won't have a problem claiming the renovation argument. But if it's less than that, then it starts to get a bit more dicey in terms of how people are going to interpret what exactly you're doing and what your quote unquote true motivations are.
I would think in many of the older areas of Nova Scotia, you shouldn't even have to go that far, because some of these buildings are in such disrepair. And even the ones that you're handling for me right now, if we had been permitted to, we would have done renovations, but we weren't able to increase rent. We wouldn't have been able to justify the repairs. So you really, and I think this goes with many provinces, you need the government and the landlords to be working in tandem, not reacting. The tenants scream, the government reacts.
Yeah.
The government reacts, the landlords react. It's got to be more of a team effort, and yes, tenants have to realize if you want a quality place to live in, it comes with a price. And yes, everybody's cost of living is going up. So are the landlords, and you can't expect somebody in business to lose money because you don't want to pay more rent. But I get it also. You have to live where you can afford to live, and it has to be somewhere that's reasonably close to where your life is, because a lot of these people don't have cars, don't have access to transport, especially in rural Nova Scotia. So it needs to be more of a team effort. The same thing going on in New Brunswick. It really, the government has to work with the landlords. And Nova Scotia, for instance, used to pay directly to the landlord the assistance that they were giving the tenants. No longer, they're giving it straight to the tenants. That's a big mistake. No, but for, and I understand why they're doing it, but the tenants, you put more money, and some of these people are not well-to-do, right? Not well-to-do financially, and a lot of them are not well-to-do beyond finances, right? And money gets put in their bank account, and they spend it. And then the first of the month comes, and they don't have money to pay for the rent. So a common thing going on in Nova Scotia is they'll pay in increments throughout the month, right? Which is a nightmare for accounting. I would love to sit in a room with someone from the government, both in New Brunswick and Nova Scotia, where the bulk of my investments are, and really dive deep into what could be done. I'm not there to tell them what should be done, but let's find solutions where Nova Scotia is putting this tax in, for instance, and I get it. There's a shortage of homes, but rather than putting this tax in, why not encourage people to build more quality homes?
And that, of course, gets impacted by the fact that you impose caps on rent, which then automatically results in people being unwilling to invest further into property because I can't invest if I can't recover. And then I kind of, when they announce all these controls or whatever, it's like, I remember my first year economics class in university where there's a whole section in my textbook. I dug out the book to talk about how what rent control does, and it effectively, net result is it reduces housing stock. It feels good, but it doesn't actually produce the result.
You're always going to have those people who need assistance, and that's fine. You have the affordable housing, and I would be all for getting involved in an investment that's affordable housing, working with the government, not opposing the government or the government opposing me. I would I believe there's a way to make money doing it. But when the government is controlling every aspect, you can't charge more rent. We're going to charge you more tax. All of the government run institutions or utilities or government contracts, you guys are being raped and pillaged when it comes to gas and oil in Nova Scotia. You have a monopoly. So you're getting your costs are exorbitant compared to other provinces, and that's why a lot of people are saying, okay, I'm cutting gas, I'm cutting oil, I'm just going to put baseboard heating, but on the tenants, right? And then you have these buildings that are decrepit because they've never been maintained. And why would a landlord maintain a building? Why would a landlord put any money into a building if they're not allowed to increase rent? It doesn't make sense. There has to be more synergy between the government and the landlords. So it's ridiculous, but it's still a better place to invest than Quebec or Ontario, in my opinion. Especially if you still can't get the rent in most areas of Quebec and Ontario. If you go to the outlying areas, you can, but even then it's getting more and more difficult. But if you stay away from Halifax and Dartmouth, it's a lot easier to make money in Nova Scotia than it is in our two provinces. And it's still relatively landlord friendly versus these other provinces. So, any other people want to know anything about Nova Scotia? Everybody gets shy. I don't understand.
Well, I can say, at least I actually had some clients in from Germany yesterday, and first time here, and he says, like, there's a lot of cranes. So here in Peninsula Halifax, like, there is a massive building boom underway. And they redid our land use bylaws about a year or so ago, and effectively created these development areas within the city. They want density, quote unquote. And so that's resulted in a lot of developers had bought up various properties that we've just been talking about, that, kind of derelict, not the greatest things, and created development sites, and just kind of sat and waited until these new rules came into place. And then all of a sudden there's about a dozen construction cranes on Peninsula Halifax. So I'm in Dartmouth, so I can look over to Halifax, and you just see it's cranes. Like, it's just unbelievable. I've never seen as many in my life. I've been here all my life. I'm 44 now. So there is a massive building influx, plus there's a massive demand for housing. So you have to keep in mind that from an investment standpoint, you'd be competing against brand new buildings going up here in Peninsula Halifax. So looking a little single family dwellings always have their own target market. Apartments have their own target market, but at the end of the day, as once these things come online, which is probably going to be another year or so for most of them, because they're all kind of at the same rate right now in terms of where they are in terms of construction. There's going to be kind of an uptick in inventory for apartments. But again, it also comes down to where people want to stay, because there's lots of apartments and the like in what's called Bears Lake, which is just outside of Halifax, kind of an industrial park area, which is just, I've been to Ontario a couple of times. It's kind of like what you would see in Ontario, just this kind of wasteland of apartment buildings. That's the best way to describe it. But they're of course in a different target market, right? People with greater mobility, cars, etc. But there's always a big demand to be on the peninsula, and so that's where this planning and development move has been, to try and get more density on the peninsula area. So you just have to kind of keep that in mind in terms of, if you're looking to invest, you've got to realize that you're going to have a lot of inventory coming online here in the peninsular area, probably within the next year and a half.
Can you touch on a little bit about, it's a particular interest of mine right now, tax sales and foreclosures?
Sure. Tax sales. These are, originally they were done through public auctions, literally a public auction. You would go and you'd bid and go through all that, just like a storage wars or whatever you want to call it. Same idea. You'd go, you'd bid, see who the winner is, you win the property. Since COVID, they've transitioned over to, as I understand it now, a sealed bid process. where you literally are just submitting your bid. And then the deadline comes, and then whoever wins, whoever's the highest bid wins. So not as much kind of flexibility as you would see in an actual public auction. But you have to keep in mind with tax sales, there's a couple things to look at. One is whether the sale is redeemable or not. And so what that means is if someone hasn't paid their taxes in a couple of years, the city puts the property up for tax sale. You go through the process of bidding. Let's say you're the successful bidder. If the sale, which would be indicated on the listing when they list the properties up for sale, if it's noted as being redeemable, that means that the taxpayer does have a chance to undo the sale. They effectively have a year after the auction's taken place.
Same here.
Same
thing here.
So that you get effectively a certificate that says, hey, you won. You get to tack that on the title to say this property has been sold at a tax sale. The current owner has a year to redeem it. In other words, pay back the city, pay everything they owe. And then if they do, great, the city will return your money and say, sorry, taxpayer got their act together. If they don't, then after that year, the city will give you a tax deed. We also have non-redeemable ones where they've literally been delinquent for so long that it is like, we don't care, we're selling it, and it's going to be full sale as of closing, so whoever wins the bid gets the property. Those ones tend to be, I won't say less desirable, but they've been trying to find the taxpayer for a long time. And like, if even the taxpayer doesn't want their land back, then that's usually not the best sign on the face of the world in terms of an investment. But the other issue with tax sales is there's been some recent case law around the validity or enforceability of tax deeds, because under our tax sales legislation, it effectively says that a tax deed is supposedly good marketable title. We, the city, give it to you. That's us standing behind title. That's good title. Here you go. There's been a couple recent case decisions referencing there's a provision in the tax sale legislation that effectively says the sale is good. However, there is a 6-year window where if it can be shown that there's been some sort of defect in the sale process itself, which is really hard to prove because you have to prove that the proper notice has been given to the taxpayer that the property is up for sale, that the city's kind of dotted all their I's and crossed all their T's. That says within that 6-year period, the tax sale could be undone if let's say the taxpayer who's lost their property is able to prove that there's been some sort of defect in the sale process. Now, the way my interpretation of the legislation is that it's presumed to have been done correctly, and that unless someone can show the opposite, then the sale's fine. And I've seen tax deeds in my chains of title. I've always viewed them as it's good title unless there's some evidence it's been a defect. There's no action started around this deed or the like, so we're fine. And generally, I take that view. However, just in the past year, there was been a Supreme Court decision that seems to allow a lawyer to claim that a tax deed that is less than 6 years old is somehow giving the buyer a right to claim that is a defect in title, and therefore I'm allowed to terminate the agreement. And that's literally what happened. That client was selling a property. They bought it at a tax sale. They jazzed it up nicely, cleaned it up, and we're selling it. And then the buyer, in this case, kind of context, the buyer realized they overpaid. They made an offer on the property. They realized once the conditions had firmed up that they was like, shit, we paid way too much for this. Because the next buyer's offer was like 20,000 less or something like that. So they decided to try and find a way to pull out of the deal. And so their lawyer claimed a title objection, say, well, yes, we have an agreement in place, but your title, you seller, you're selling this property to me, you took it at a tax sale. The tax sale deed is less than 6 years old. So I'm saying that, I'm objecting to the title because you can't guarantee to me that within the next couple of years, someone's not going to show up and cause a problem. So that's my objection. The seller said, F you, it's good, we're closing. They tendered, went through the whole process, and of course then proceeded to sue the buyer to say, well, you breached the contract. Yeah, your title objection is not a valid objection. Unfortunately, our Supreme Court, in what I consider to be a misinterpretation of the law, said no, it actually is a valid objection. It's a presumption that it's good, but that's not a guarantee, and so therefore you can object. So needless to say, it's now kind of the real estate bar, and this has just been in the past couple of months. So the real estate bar is still kind of scratching their heads a bit, trying to figure out, well, what is it then? We thought it was good for all these years, but now maybe it isn't, which then, of course, calls into question the entire tax sale process generally. So no city could be, based on if you take the logic of the decision all the way through, then any city selling a property at a tax sale and gives a deed should be announcing at the start of every auction that, oh, by the way, if you win and you get this deed, you'll have a very difficult time selling this property within the next 6 years, because someone could, in theory, object to your deed to say, well, it's not been done properly. And according to the Supreme Court of Nova Scotia, that's somehow a valid title objection. Now, whether that's going to get changed as this, I know a couple of my colleagues have written to the government about it, just to say, you guys need to look at your legislation then, because if the court's interpreting it this way, that's not really what the intent of this whole tax sale process was. The idea of a tax sale is to get the property put into use. That the current owner has not paid taxes, they don't seem to be interested in utilizing the property. So let's move on, get it sold to someone who wants to utilize it. But based on this interpretation of the legislation, it seems to be now that you were maybe preventing this from happening. So you guys need to go back and take a look at how your tax sale legislation is worded and how the courts interpreted it to see if we can get a better way to get this resolved, because nobody wants to buy a property and then find out that, oh, by the way, for the next 6 years, if you try to sell it, there's a chance, depending on what the buyer wants to do, they may try and pull the plug on you by pointing to this case and saying, oh, by the way, your title is not good, so I don't want to go ahead.
That's brutal.
It is. It's the most bizarrest decision I've seen. And it just came out in the past couple of months. So it's really kind of like, Jesus, what's all this? So, I mean, tax sales are certainly useful, but you now have to kind of keep this in mind until such time as, either the legislation gets amended or the courts take another look at it, that it could be opening a side door if you buy a tax sale property and want to try and sell it within 6 years. This could rear its head on you.
With that train of thought, couldn't they expand that to any sale?
No, tax sale, it's just the way the legislation is worded. So for any sale, let's just say you're buying a property from a third party, they give you a warranty deed. That seller is warranting under the deed that they have good marketable title, full stop. With a tax sale deed, it's based on the legislation, which specifically says that this is a tax sale deed. It's done in accordance with the legislation, and buried in the legislation is the provision that says this could, in theory, be undone within 6. It's presumed that everything's fine, and a buyer can rely on that presumption. However, that the tax sale could be undone if a defect's found. But the remedy for that, if a defect is ever found, is effectively between the taxpayer who originally owned the property and the city. So the third-party buyer who buys the tax deed gets the property from the municipality and pays for the tax deed. That's my interpretation has always been that's done. That's moved on. If the taxpayer feels that they've lost their property because of the city's misbehavior or the like, that's between them to sue and sort it out. You're the third-party buyer. You got the deed. The presumption is the deed is fine. You get to go on. That's always been my original interpretation. However, now the court seems to have a different interpretation. And that's why myself and most of my colleagues seem to take the view that this is not interpreting the legislation the way it was intended. The third-party buyer buys property at the tax sale should be allowed to go on and not have to worry about this. They enjoy a presumption of, it's called the presumption of regularity. Everything was done correctly. You get to go on with your deed. And if the taxpayer has somehow been deprived as a result, then they can go after the city within 6 years. It shouldn't be involving the third party who's bought the property.
Wouldn't the argument be, again, I'm curious because I don't ever want to fall into that trap, but wouldn't the argument be, if you're going to buy a property at a tax sale, now it's not going to change the fact that you're buying the property, but you're going to have that building inspected and remedy any issues that are in the property before selling it, or you have to declare it forward?
Oh, well, this is a little different. This is the idea that if the municipality, in terms of its actions, how it conducted the tax sale, this is where the issue comes in. So if the municipality didn't give proper notice to the taxpayer, for example, that the property was going up for sale, and that taxpayer can prove that within the 6 years, then they can seek to get a remedy against the municipality. However, our courts now interpreted that more broadly. It seems to be the idea that, well, given that that's a risk, whoever's buying the property from you is the one who won at the tax sale. They could point to that possibility and say, well, your deed, that your tax sale deed that you got is not 100% guaranteed that you own it. That, you know, someone could challenge the municipality and all of a sudden this could result in you not having an interest in your property. Do I agree with that interpretation? No, I think it's incorrect. But given the most recent court decision says that that's a valid title objection, then all of a sudden now it calls into question that if I buy a property at a tax sale and I hold a tax sale deed as the deed coming into me, suddenly now if I try to sell it, buyer could say to me, well, when you buy that, David? Less than 6 years ago? Well, according to this case, I can't remember the reference off the top of my head, the court's interpreted to say that I could object to your title, to say your title is not perfect. You've got a flaw because this issue could happen within the next 6 years. So I don't want to buy it. Now, have I done a couple sales since this case where, you know, the owner had a tax sale deed and it went ahead without a problem? Yep. Is that a guarantee that, you know, this objection couldn't come up in the future on another sale? Nope. It's kind of just floating out there in the ether as, honestly, it's a tool for someone who exactly kind of the fact scenario where this case came about is the buyer had changed their mind, realized that they're overpaying, and tried to weasel their way out, and they found a way. And now this kind of weaseling exit is floating around as a possible objection.
You're at the mercy of bureaucratic mistakes.
Yeah, exactly. I think the case is wrongly decided. I think it's an error on the part of the court, but it's the court's decision. And so now it comes down to government to figure out how they're going to reinterpret this. So we reached, I think a couple lawyers have reached out to the Registrar General of Land Titles and local municipal governments to say, hey guys, by the way, your tax sale deeds have suddenly been found to be flawed, and buyers could wind up, you know, getting a tax sale deed from you and then not being able to sell it for 6 years, which I don't think is your original intention. So you may want to have another look at this.
Would the buyer of the tax sale be able to sue the city, the municipality, for that?
Well, that's the interesting thing. It's because this has all been just recently decided, right? The argument is, well, I as a successful bidder at the tax sale have the presumption of regularity that everything's fine. If the third party says, who buys from me, who out of my tax sale deed says, well, no, that's a flawed deed, I don't think there would be a remedy against the city, because ultimately what would happen is I still have the property. It's in my name now. The remedy would be as between the taxpayer and the city in terms of getting recovery. They would say, well, you city, you wrongly deprived me of the deed, wrongly deprived me of my property. You owe me money. I don't see it impacting the person who won at the tax sale being able to sell or to deal with the property. The problem is the buyer is in the position to object to the deed, and that objection has now been upheld by our Supreme Court, even though I think it's not a valid objection. They've interpreted it as being a valid objection. And so that buyer could get out of the deal. Now, do I think your title is flawed? No, I don't think so at all. And I think even if the worst case scenario was flawed, let's say the municipality messed up the sale, didn't give proper notice, there's been all kinds of problems, you won the tax sale, the city gave you a deed. If there are any problems, that still remains between the city and the original owner of the property, not you. You paid good money for it. The city's not going to take it back from you. They're going to have to deal with the original owner and settle with them. Mm-hmm. So it's a delightful mess is the best way to describe it. So tax sale is still interesting, but there's now a new twist in terms of if you're going to try and flip that thing on to another party, there's an increased risk that new person could try and make a title objection argument to say, well, I'm not really happy with the deed you have. I want out.
So where's the opportunity for a buyer? There's got to be an opportunity if there's a seller.
The opportunity for the buyer is you may be a buyer that's willing to take on the risk, such that it is, in terms of buying from a third party from a tax sale, or if you're getting a good deal and you're able to sit on it, then there's another opportunity here. Again, the case has been recently decided, so it's not everywhere. Like in the most recent one I was expecting the lawyer for the other side to call me up and say, David, we read this decision. We don't want to, we're objecting to title. But no, they went ahead, because in my case, the guy was buying it from someone who bought this land at a tax sale. Young guy wanted to buy a lot to put his house on. And he said, well, I'm getting a good deal. I'm not too concerned about it. I'm not going to be building anytime in the next couple of years. And realistically, I don't think it's a big risk. I want to go ahead. So he just went ahead. So it's more of a kind of an abstract concept in terms of it's the biggest risk I see is someone using it as a reason to get out of a deal if they want to. And so if you buy a tax sale property, then you flog it, and then you get, not to be kind, you get a sucker willing to pay a hell of a lot more money than what you paid for it. And then they realize before closing that they want to change their mind. They now suddenly have a legally sanctioned route out, I guess is the best way to describe it. So that's kind of the risk.
Okay. And how about a little bit on foreclosures in Nova Scotia?
Foreclosures, I've done a couple, literally acting for banks and the like. Good opportunity. Main downside, of course, is you don't see the property. You have no right to go in it. You can drive by it and look at it, but you are literally buying that sucker, unseen on the inside. You can look at it from the outside, from the public road, but you can't step foot on that land because it's not yours. The vast majority of tax sales wind up being purchased by the banks. Very, very few people actually go to the auctions. The most recent one I did for a house, I was acting for a private lender that foreclosed on it. The owner unfortunately died. Was no real assets in his estate for us to get money. So my client had no choice but to foreclose to realize on the property. So we went through the process, foreclosed. I went to the auction on behalf of the bank. The auction takes place at the courthouse. Nova Scotia gives effectively Ontario has effectively power of sale legislation, where effectively the lender can just sell it without much oversight of the courts. Nova Scotia is under called the old system, kind of the English system, where it's a court supervised foreclosure process. So we literally have to go to court, convince a judge that here's the mortgage, we haven't been paid. We wish an order of foreclosure, sale, and possession to give us the power to sell the property. We can either, as the lender, if we want to take the property, we have the choice of either having the high sheriff of the county we're in, Halifax County usually, conduct an auction, or we can retain our own private auctioneer. And that's usually what we do because it's a lot cheaper. And that private auctioneer is literally just another lawyer who we effectively, in the foreclosure order, we say, all right, we are going to designate this lawyer as the auctioneer. And here's the instructions that will be given the auctioneer, how to conduct the auction, et cetera. It's literally just scheduled to the order. And judges are fine with that. And so they'll say, yep, okay, we grant you your order, Mr. Melvin, here you go. Order of foreclosure has been issued. We then record that on title. We then go through an advertising process for the auction, which requires 2 advertisements to be placed in a local newspaper to announce it when the auction's taking place. But then even with all that advertising, 95, 96% of the time, you go to a foreclosure auction at the courthouse, you'll see the auctioneer, who's usually, like I said, a private one lawyer, and another lawyer, namely the lawyer for the bank, in this case myself, sitting in a room together. And we wait till 11 o'clock. And it's like, all right, there's nobody. Mr. Melvin, what's your bid? And it's like, well, I bid, literally your fees and the outstanding taxes. That's my opening bid. And it's like, anybody else? Nope. Okay, property's yours. There you go, done. However, when it does happen, and in my case, actually, it turned out that we had a third party come in who kind of one of their businesses is buying up tax sale or foreclosure properties. And so we came in and she arrived, and so we proceeded to bid. And my instructions from the lender, which are normal for every lender's counsel at a foreclosure auction, is you have to go to the auction, and my job is to sit there and keep putting up my hand until we bid the value of the property up to either what's owed on our mortgage plus all the expenses, or we usually get an appraisal done before we proceed and bid up to the market value of the property, whatever's the lower. Now, as lenders, we usually pray that there's more value in the property than what we're owed, and so we get all our money back, and that's it. And so in my case, for example, with the fellow who died and we were foreclosing on it, we actually bid it up to everything we were owed, plus all my fees. And then the woman who was in the auction with me bid $1 more, and I put my hand down because like, great. So she won the house. She had to pay, literally the full value of everything my clients were owed, plus our costs, and $1 extra. And we closed the deal. She bought the foreclosure property. My client was happy as the bank. We got fully paid. I was paid. Off we go. So kind of the ideal scenario for a lender at a foreclosure auction. We didn't wind up with the property. We got all our money back. Perfect. So lenders are quite happy to see other people at the auction, but you as being the other people, obviously have to be careful because you don't want to, wind up buying lemons, which is the higher risk because you don't get to go inside the properties, right? You get to see them from the street and that's it. This person who, in my case, bought the property, I think they did quite well on it. I saw her relist it and sell it for, a healthy chunk of money. So it worked out well for them. But that's, that really just depends on the property and where it is. In terms of getting information about foreclosures, like where to find them, we obviously there's advertisements in the newspapers in Nova Scotia. But one thing you may want to look at is there's a website called allnovascotia.com. It's effectively a private news service. It's kind of like I won't call it, it's kind of like it's a business gossip rag, I guess is the best way to describe it. You pay a and don't get me wrong, like every law firm, every banker, everybody's got a subscription to this thing, even though they or may not say it, but they do. And they literally have someone hired they go to the courthouse every day and they look at the auctions and there's a section on the site where they'll list like every day. It's like, oh, here's what's, who's suing who and foreclosures and, again, kind of the business gossipy thing in terms of what's going on. But I mean, I've literally had clients sue people just because they know it's going to get in all Nova Scotia and they want to just kind of put the word out on certain things, so they go through the motion. But it is a fairly useful tool in terms of if you're not down here and you can't physically go to the courthouse and you're not subscribing to the Chronicle Herald, the local newspapers. It's a pretty, like, it's only a couple bucks a day, or I think it works out. We have a subscription here at the firm. We get 6 licenses or whatever, and I think it's like $50 or $40 a month or something like that. And
I used to have one.
Yeah. And it's an interesting read. You get to kind of see what's going on from a business standpoint. And also it gives you this access to stuff in the courthouses where otherwise it'd be a real pain in the butt to go look at. The site is cleverly designed, so you can't print it. You can't cut and paste from it. Like you literally need a subscription. It's the only way you can read it. But it is kind of a useful tool to kind of know what's going on down here. Just in terms of general business, developments, what people are doing, a little bit of gossip, but also, as I said, it's kind of a useful tool from the courthouse standpoint to see what's going on, what's coming up for sale, and using that and other tools, just Googling, you can kind of see, this foreclosure property is going on. It's like, well, let's take a look at it, and Google Street View, whatever, you have a look. I was like, yeah, that looks a little interesting. And then it gives you a chance to, okay, well, let's drill down a little more. Or you do Google Street View and you see it's, a burnt out wreck or whatever. You decide really quickly, it's like, that's a nice foreclosure property, but I ain't bidding on that.
If it was a rental property, are you obligated to keep the tenants?
I'm pretty sure under the Residential Tenancies Act, you're not. There's notice. You'd have to give a certain amount of notice to the tenants if it's sold at foreclosure, but a lease is like anything. It's an interest in land. However, a foreclosure auction wipes out all prior interest in the land at the act upon literally the auctioneer's hammer coming down. But there are tenancy protections that give those tenants some grace period to get out. You just can't show up and throw them out. but I'm pretty sure that there's a provision in there that lets, as a successful bidder at an auction, to remove the tenants. But realistically, if there were tenants there, you could probably ask the lender's counsel, because they would know. If it's a rental property, normally lenders would have an assignment of rents on title as well, where if the current owner fails to pay, then the bank can literally go to the tenants and provide them with a copy of the assignment and say, by the way, your landlord's no longer, for some reason, has stopped paying us. Guess what? You, the tenants, are now sending the money to us. And here's our legal right to have you do that. And here's our instructions on where you send the money. So 99% of the time, if there is a rental going on, the bank's lawyer would know. And the bank's lawyer is not going to keep a secret from you or anything like that. They're there to sell the property. They're not going to help you buy it. That's not their job. You're not their client. But at the same time, they're able to provide basic information as to what's going on. And usually it would, or worst case, you'd call someone like me. I'd call up the lawyer myself and say, hey, I've got a client that are looking at going to the auction. Tell me the story. What's going on here? And like I said, 9 times out of 10, they're willing to tell you. They're not going to, their ultimate goal is, their client, the bank, doesn't want to own this thing. So, hey, more bidders the merry. Come on down, try and buy the thing from us. We want to get our money out of this and we can go on, as opposed to what usually happens is the bank winds up winning at the auction. And then they got to sell it and then try and get what they can for it.
And they don't want that. No,
it's just more work for them, right? And they lose effectively, they can charge all those additional costs to the original borrower and go through that circus. But usually if the lender's not paying them, they're probably in trouble. And as a result, they're probably not going to see all their money again, but at least they're going to recover at least most of what they're owed. But once in a blue moon, which I've actually had happen to clients, is thanks to the pandemic, my client foreclosed on a property, was the only bidder. So we won, bought the property, and we wound up with the property being worth more than what we were owed. So my client, the lender, literally got a windfall. They won at auction a property that was worth more than what they're owed. And as the successful bidder, we're under no obligation to pay the former owner back any surplus. So in this case, the current owner, if they were smart, they should have gone and just refinanced. The property was worth a lot more than what they were owed. If they just refinanced and paid my guy out, they would have been laughing. They would have been ahead of the game. But they didn't. So we wound up foreclosing, took the property, and now we sold it for more than what we were owed. And too bad, so sad for the guy who borrowed from my clients. But yeah, it just kind of, in a fluke, usually rarely ever happens for a bank, where we wind up winning is the property being worth more than what we were owed. And we get a windfall.
David, thank you so much for spending an hour of your Saturday with us.
Hey, no problem. My pleasure.
And hopefully we can have you back on in the future.
Yeah, sure. And we can look at, if you've got specific things you want me to look into, and we can certainly tailor a more specific presentation to certain issues or the like. I'd be happy to. Awesome.
Any last questions before we let David go and enjoy his Saturday? Well, finish his work and then enjoy his Saturday.
I have a quick question. Maybe you can answer it quickly because I know the time is up.
Oh, no worries.
Can you talk about the rule where if you're buying a second home in Nova Scotia, that you only have to pay 5% down? And how many times can you buy a second home? And what happens if you buy it and you decide you don't want to live in it, but you want to rent it out, etc.?
Okay, a lot of this deals with kind of the CMHC and their rules around, the minimum down payment you have to put on a property is 5%. Now, officially, if you're buying a rental property, for example, that you're never going to live in, most banks will require you to put 15 or 20% down, just because that's an investment property. It's not your principal dwelling. Those lenders, I'm not familiar with the idea of buying a second property and only putting 5% down. If that's available, great. But I'm not sure the specifics around your case. But in those cases, normally what happens is the lenders, especially if you're dealing with a chartered bank, for example, they will have you as the borrower sign a declaration confirming whether or not you are going to be residing in this property or not. Now, have I had clients come in and sign a declaration saying, yes, we're going to live in this second property? and then turn around and call me a month later and ask for help doing the lease? Yes. Is that an act of default under the mortgage? Yes. And if the lender finds out and they want to call it in, they in theory could. They could point to a covenant in the mortgage that says, you said you were going to live here. You're not. We're calling it in. Do lenders run around and check every property all the time? No. So I always caution clients when they look at this, and if there's a declaration where they're saying you're going to live in it, I tell them, it's like, you're confirmed to the bank you're going to live in this. And if you decide next month you're going to be renting this out, there's a higher risk that if the bank discovers that and they get nervous, they could call you in and say, no, you got to pay us. It's due.
Are you under an obligation to tell the bank?
It depends on the scenario. So if I'm representing you and borrowing the money at the time of closing, and you blurt out to me at the meeting that this is what I'm doing, I'm obligated to report to the bank because I represent their interests in the transaction. Now, if the lender has its own counsel, that's different because I'm not representing the bank in that transaction. But 9 times out of 10, if it's a residential purchase, 1 or 2 units, generally speaking, the lenders say, well, David, you can represent us as well. The clients are just borrowing the money. You go ahead and do it all. So literally at the start of every meeting the first thing I have the client sign is something called a retainer direction to pay, authorization, and informed consent. And that effectively covers kind of all the nuts and bolts of me representing you. But the informed consent part is where I tell you that, by the way, I'm acting for the lender in this transaction as well. So everything you say to me in this meeting, you have to assume the bank is in the room listening. So I always tell clients, don't blurt out anything you don't want the bank to hear, because I'd have to tell them. My usual example is if you blurt out to me that you just lost your job before we close, that's a material change in your circumstances. I'm obligated to report that to the bank. So that usually means bad things would follow. Because if I have to call the bank for something, it's usually not good. So if I learn that, like I said, your situation's changed, like you just lost your job, or you told the bank one thing and you're doing another, I have a duty to them to inform them on what's going on. And that usually results in bad things following. So I always tell clients the secret is don't tell me anything you don't want the bank to hear when we're doing a deal. Now, I'm not telling people to lie or anything like that, but factually, I'm presenting to the bank all the information, and I have to act as a quote unquote careful and prudent solicitor. And if I discover that there's flaws or risks to the bank, I'm obligated to report that to them. But at the same time, I'm taking the word of the client in front of me, because surprisingly, people do lie to their lawyers all the time. Which is very, very frustrating because we're trying to help. And if you don't tell us the truth, we can't help you. So that's kind of the challenge we run into. So yes, there is a 5% down on properties, but there are rules around it. And you have to fit within those rules in order to qualify for it. And the banks will check as part of the transaction process. And their main way of checking is literally relying on your honesty and saying, well, you're going to sign this declaration that says you're going to be living here. If you show up to my office 2 months later saying you're renting it, that's puts me in a very awkward position. And I usually would say, well, you're going to have to go somewhere else because I can't represent you and be in a conflict with what the banks told me as my instructions are on what you told me at our meeting. I'm not going to be running around calling the banks, but at the same time, I'm not going to go further in terms of representing someone if I feel that I'm going to be put into a conflict position after the fact. Now, if it's 3 years later and there's a family change their situation and you have to rent the home because you did live in it, I see that as being a little different. You did confirm you were living there, life changed, you had to do something, and you now want to rent it. I see that as a little more flexible than this is my 3rd property I'm telling the bank I'm living in, and because you just want to do the 5% down thing, that's a point where I wouldn't be able to represent you going forward just because I would know factually that that's just not true. And again, not suggesting anyone here is going to be dishonest or doing anything wrong. It's just these are the parameters a lawyer faces when we deal with a client, is that you're telling us certain facts and we need to make sure they're true. And if we learn they're not true, we are obligated to report to the bank as part of the leading up to the funding of the transaction as to what's going on. And if we learn something's changed, we have to tell them.
Actually, I've heard a lot of investors talking about buying property for the purpose of using them as an Airbnb, for example.
Yeah.
And not telling the bank, because the banks don't particularly like short-term rentals.
Right.
And most of them won't lend on them, and they'll tell them, you know, this is going to be a secondary residence or my primary residence or my wife's, you know, like,
Yep.
they're going to find out. Eventually, they're going to find out, and it's going to come and bite you in the ass, and you might not ever get a mortgage again in the future. And if I'm not mistaken, some banks actually have started up departments where they're combing Airbnb to see if any of these properties are properties they've mortgaged
with their records to say, oh wow, we got a loan on that house.
Yeah. So you know what? Like, do things on the up and up, and
I know
have integrity.
You never have to worry if you follow the rules. And you know, like any group of people, investors, there are some who want to kind of skate on the edge, and they give lawyers gray hairs as a result. But if you stick to the four corners of the rules, you'll never go wrong.
Well, you can bend the rules, you just can't break the law.
Yeah, exactly.
Okay. Well, on that note, my friend, I will let you go. I have to. I have a big appointment with my bed for the rest of the day. And thank you for taking the time. It's always a pleasure chatting with you, and we'll catch up soon.
Absolutely.
And hopefully we'll be closing on the sale of those 8 buildings soon.
Knock on wood.
Have a great Saturday.
You too. Thank you all.
Thanks, everybody.
Thanks, David.
Bye for now.